Gonna pick up just in recommendations. A communication about a lawyer's services is a recommendation if it endorses or vouches for a lawyer's credentials, abilities, competence, character, or other professional qualities. Subject to the exceptions below, the lawyer must not compensate, give anything of value, or promise to give or group advertisements anything of value to a person or for recommending the lawyer services. Note: directory listings or group advertisements listing lawyers by practice area without any further information do not constitute prohibited recommendations. Exceptions to general rule. A, paying for advertising or other services. A lawyer may pay the reasonable cost of permitted advertisements, i.e. broadcast airtimes, directory listings, or newspaper ads. Additionally, a lawyer may pay the usual charges of 1, a legal service plan, 2, a not-for-profit lawyer referral service, or 3, a qualified lawyer referral service. Qualified means that the service has been approved by appropriate regulatory authority. A lawyer who accepts assignments or referrals from a legal services plan or a lawyer referral service must ensure that the organization's communications comply with the lawyer's obligations, that is, are not false or misleading. One, under paying for advertising and services, is paying others to generate client leads. Lead generators provide consumers with matching referral and directory services. For example, a consumer goes to a website, selects a type of legal problem, and is provided with a list of lawyers who provide that service and the ability to select and contact one of those lawyers. The lawyer may pay others to generate client leads as long as the lead generator does not recommend the lawyer and the lead generator's communications are not false or misleading. A communication by the lead generator is false or misleading if it creates a reasonable impression that Romanet 1, it is recommending a lawyer, Romanet 2, it is analyzed the person's legal problems and determining whether to refer the person to the lawyer, or Romanet 3, it is making the referral without any payment from the lawyer. Purchase of the law practice. Of course, the lawyer may purchase a law practice even though the seller is, in a sense, recommending the purchasing lawyer to her clients. Reciprocal referral agreements. Under certain circumstances, a lawyer is permitted to set up a reciprocal referral agreement with another lawyer or with a non-lawyer professional. For example, I will refer potential clients, patients, or customers to you if you do likewise for me. Another lawyer means a lawyer at a different firm. The rule does not restrict referrals among members of the same firm. The term non-lawyer professional is not defined, but is generally interpreted as a person who belongs to a professional body that requires a high level of proficiency and regulates its members, doctor, accountant, insurance agent, for example. A reciprocal referral agreement is subject to the following restrictions and guidance. It must not be exclusive. The referred client must be told about the agreement. If the agreement creates a conflict of interest for either the referring or the receiving lawyer, then the lawyer must obtain the client's informed consent confirmed in writing under ABA Model Rule 1.7. Of course, one must wonder whether reciprocal referral agreement invariably creates a conflict because it gives the referring lawyer a personal financial interest in sending the case to its referral counterpart rather than to some other lawyer. 3, the reciprocal agreement must not interfere with the lawyer's professional judgment as making referrals or providing substantive legal services. And 4, the agreement should not be of indefinite duration and should be reviewed periodically to make sure it complies with ABA model rules. Nominal gifts or gratuities. A lawyer may not give a nominal gift or gratuity as an expression of appreciation. May give a nominal gift or gratuity as an expression of appreciation to a person who recommends the lawyer or the lawyer's firm, provided the gift or gratuity was not intended or reasonably expected to be a form of compensation for recommending the lawyer's services. Such gifts must not exceed a token item that would be given for a holiday or in the course of ordinary social hospitality. A gift is prohibited if offered or given in consideration of any understanding that the gift would be forthcoming or that referrals would be made or encouraged in the future. Solicitation. A solicitation is a communication initiated by a lawyer or firm that is directed to a specific person the lawyer knows or reasonably should know needs legal services in a particular matter and that offers to provide, or can reasonably be understood as offering to provide legal services for that matter. However, a communication is not a solicitation if it is is directed to the general public through a billboard, website, television commercial, internet banner service. And 2, responds to requests for information, or 3, is automatically generated in response to an internet search. 1, live person or person solicitation generally prohibited. Subject to the exceptions below, a lawyer or firm may not by live person-to-person contact solicit professional employment when a significant motive for doing so is the lawyer's or firm's pecuniary gain. Live person-to-person contact means in-person, face-to-face, live telephone, or other real-time visual or auditory person-to-person communication, i.e. Skype or FaceTime, where the targeted person is subject to a direct personal encounter without time for reflection. A, exception to the prohibition, number 1, is significant motive is not pecuniary gain, or 2, certain targets are considered less vulnerable. So offers to provide free legal services are generally permissible. Furthermore, certain political or ideological solicitation, i.e. on behalf of civil rights organization or nonprofit organization, is constitutionally protected. Certain targets are considered less vulnerable. Subject to the limitations in 3 below, a lawyer is generally not prohibited from initiating live person-to-person contact with 1 other lawyers, 2 persons from whom the lawyer or firm has a familial, close personal, or prior professional or business relationship, including current or former clients, and 3, routine business users of the type of legal services offered by the lawyer or firm, for example, entrepreneurs, small business owners, executives who hire counsel to represent an entity, and any other persons who regularly engage lawyers for business purposes. 2, written, recorded, or electronic solicitation generally permitted. Generally, a lawyer is not permitted from sending truthful, non-deceptive communications via mail, email, text message, chat room message, etc., to persons known to face a specific legal problem. These types of communications can be easily disregarded by the recipient and do not constitute live person-to-person contact. Email, text message, chat room, mail. Okay. Because they're written and they're not live. Circumstances rendering all contacts impermissible. A lawyer is prohibited from soliciting professional employment regardless of what method is used or who the target is. If A, the target of the solicitation has made known to the lawyer that she does not want to be solicited by the lawyer, or B, the solicitation involves coercion, duress, or harassment. Communications authorized by law or court order under the solicitation, there's this last 2 sections, this and the use of agents to solicit. So for communications authorized by law or court order, these rules do not prohibit communications authorized by law or order by a court or other tribunal. For example, in a class action litigation, a notice to potential members of the class. And 5th, under solicitation is the use of agents to solicit. Recall that a lawyer is always prohibited from using an agent to do what the lawyer must not do. For example, violate the law or disciplinary rule. Thus, a lawyer must not use an agent, sometimes called a runner or capper, to contact prospective clients in a manner that would violate the rules of professional conduct. D, group and prepaid legal service plans. Group or prepaid legal service plans typically are part of an employee benefit plan and bear some resemblance to health insurance plans. Participants typically pay a monthly premium in return for which they may consult a plan authorized lawyer and obtain legal services for a low or no cost. Such plans vary widely as the services provided, ranging from a brief consultation to full representation, and as to the areas covered, ranging from estate planning to divorce to civil or less commonly criminal actions. 1, a lawyer may personally contact sponsoring organizations. A lawyer or firm may personally contact representatives of groups that might wish to adopt a legal service plan for its members, beneficiaries, etc. This is more akin to advertising than solicitation because it is not directed at people seeking legal services for themselves. The representatives are acting in a fiduciary capacity and seeking legal services for their members who will later choose whether to become a client of the lawyer or firm. Two, plan may, and this is two under the group and prepaid legal service plans. A plan may personally contact potential members. Lawyers are permitted to communicate in a group or prepaid legal service plan, even though the plan uses live person-to-person contacts to enroll memberships or sell subscriptions, provided that one, the personal contact is not undertaken by the lawyer themselves, and two, the plan only contacts persons who are not known to need specific legal services in a particular matter covered by the plan, as this is not fall within the definition of solicitation. And A, within that section, is participating lawyer must not be owner or director. A lawyer must not participate in the legal service plan if the lawyer owns or directs the organization that operates the plan. Third, under this whole section of group and prepaid legal service plans, is must assure compliance with advertising and solicitation rules. A lawyer who participates in the legal service plan must reasonably assure that the plan sponsors are in compliance with advertising and solicitation rules, i.e. must not advertise in a false or misleading manner. Subpart E is titled Government Regulation of Communications about Legal Services, and this is E within Part 10, Communications about Legal Services. So the Supreme Court has recognized lawyer advertising as commercial speech protected by the First and 14th Amendments, holding that a state may adopt reasonable regulations to ensure that lawyer advertising is not false or misleading, but may not flatly prohibit all lawyer advertising. 1, false and misleading ads and in-person solicitation may be banned. 2, disclosure requirements for misleading communications, the rational basis test. 3, other regulation of truthful, non-deceptive communications, the intermediate scrutiny, and that's that. So there's no strict scrutiny test. But anyway, for false and misleading ads and in-person solicitation may be banned. A state may flatly prohibit lawyer advertising that is false or misleading. Similarly, a state may adopt prophylactic rules to forbid in-person solicitation for profit in circumstances that are likely to result in overreaching or misleading a layperson. In practice, misleading communications and in-person solicitation are regulated rather than completely banned. 2, disclosure requirements for misleading communications, rational basis test. To prevent commercial speech from misleading consumers, the government may require commercial advertisers to make certain factual disclosures if such a requirement is 1, not unduly burdensome, 2, reasonably related to the state's interest in preventing deception, and number 3, other regulation of truthful, non-deceptive communications by intermediate scrutiny. Because attorney advertising is commercial speech, regulation of it is subject to only intermediate rather than strict scrutiny. In the Florida Bar verse Went For It, Inc., 1995. Thus, this type of commercial speech may be regulated if the government satisfies the 3-pronged test. 1, the government must assert a substantial interest in support of its regulation. 2, the government must demonstrate that the restriction on commercial speech directly and materially advances the interest. And 3, the regulation must be narrowly drawn. In this case, Florida Bar versus Went For It cites Central Hudson Gas and Electric Corp versus Public Service Commission of New York. So I guess the example is here, and I really like this case. After conducting a 2-year study on the effect of lawyer advertising on public opinion, which includes surveys and hearings, Florida adopted a rule prohibiting lawyers from sending any targeted direct mail solicitation to victims and their relatives for 30 days following an accident or disaster. The United States Supreme Court upheld the regulation, finding that it met the 3-pronged test above. The court found that 1, the state has a substantial interest in protecting the privacy and tranquility of its citizens, as well as protecting the reputation of the legal profession. And 2, the studies show the public was offended by these solicitations and that the 30-day ban directly advances the state's interest. And Romanet 3, the regulation is narrowly tailored to achieve the desired results. So that is not the case I thought it was, but either way, I need to know the difference. Part 11, lawyers' duties to the public and the legal system. I'm going to be brief here. There's A, pro bono publico service, B, court appointments, C, limited legal service programs, D, membership in legal services organizations, E, law reform activities affecting client interests, F, assisting in judicial misconduct, and G, statements about judicial and public legal officials, which says here, a lawyer must not make a statement that the lawyer knows is false about the qualifications or integrity of a judge. So knows is false. Qualifications or integrity of a judge, hearing officer, public legal official, or about a candidate for a judicial or legal office. The same rule applies to statements made with reckless disregard as to the truth or falsity. H, lawyer running for judicial office. I, ability to influence government officials. A lawyer must never state or imply that he has the ability to improperly influence a government agency or official or to achieve results by means that violate the law or legal ethic rules. And J, prohibit political contributions to obtain government employment. Prohibited contributions. So this is for the purpose of obtaining such employment or appointment. A pay-to-play contribution. Prohibited contributions are those that would not have been made but for the desire to be considered for the employment or appointment, and a whole bunch of stuff. Plus 2, under the political contributions is excluded employment. Exclusions to this rule, model rule 7.6, that is 1, uncompensated services, engagements, or appointments made for the basis of experience, expertise, qualifications, and costs, following the process that is free from influence based on political contributions. And 3rd, engagements or appointments made on a rotating basis from a list compiled without regard to political contributions. So, just going back over the lawyer's duties to the public and legal system. In the court appointment section, this is divided into 3 parts. There's the violation of law or disciplinary rule, the unreasonable financial burden, and the personal inability to represent the client effectively. And I think that's when a lawyer may avoid an appointment for good cause. Good causes are if accepting it would require the lawyer to violate a law or disciplinary rule, whether there's an unreasonable financial burden on the lawyer, and personal inability to represent the client effectively. And for limited legal services program, this is divided into 2 parts. There's the client consents to short-term limited legal service and the applicability of ethical rules. And, there's more. 3, conflict of interest are relaxed. 4, imputed conflict rules also relaxed. 5, conflict rules apply fully if quick advance leads to regular representation. I'm going to read that section because I know there's at least one question on it. This is some courts and nonprofit organizations have established limited legal services programs in which lawyers offer quick advice to people who can handle their own legal problems without further assistance. Examples are programs that show people how to fill out their own easy tax forms, legal advice hotlines, advice-only legal clinics, and programs that show people how to represent themselves in small claims court. A lawyer-client relationship exists between the lawyer and the person who obtains the quick advice, but neither person expects the relationship to continue past the quick advice stage. The lawyer may participate in the quick advice program sponsored by a court or nonprofit organization subject to the following rules, and that's the client's consenting to the short-term limited legal service, and or they're advised to get further legal help if they're not, acclimating, and then applicability of ethical rules. 3, conflict of interest rules are relaxed. So a lawyer who participates in a quick advice program ordinarily has no time to conduct an ordinary conflict of interest test. Check. Therefore, the general conflict principles expressed in 1.7 for current clients and 1.9 for former clients do not apply unless the lawyer actually knows that giving a quick advice creates a conflict of interest. As in other contexts, actual knowledge can be inferred from the circumstances. 4, imputed conflict rule is also relaxed. The rule of imputed conflict of interest is also relaxed in a quick advice situation, and this is Model Rule 110. Therefore, a lawyer may dispense advice in a quick advice program unless the lawyer actually knows that he is disqualified from doing so because of a conflict imputed from another lawyer in his firm. Conversely, a conflict created by advice a lawyer dispenses in a quick advice program will not be imputed to others in the lawyer's firm. And lastly, conflict rules apply fully if quick advice leads to regular representation. If a person who has received quick advice from a lawyer then wants to hire that lawyer to render further service in the matter, the ordinary conflict of interest rules apply to that further service. D is the membership in legal service organizations. It's only 2 short sections, a statement of the problem and the general rule. So this is like free legal assistance to underprivileged persons in civil matters. An officer or member of an organization does not have a lawyer-client relationship with persons served by the organization, but there can be potential conflicts between the interests of those persons and the interests of lawyers' regular paying clients. So how are you going to know the difference between a legal services organization and a limited legal services program? I don't know. I guess it depends on the duration. So the general rule is a lawyer may serve as a director, officer, or member of the legal services organization apart from the lawyer's regular employment, even though an organization serves persons whose interests are adverse to the lawyer's regular clients. This general rule is, however, subject to the limitations stated below. 1 and 2. 1, the lawyer must not knowingly participate in the decision or action of the organization if doing so would be incompatible with the lawyer's obligations to a client under the client general conflicts of interest rules. And 2, the lawyer must not knowingly participate in a decision or action of the organization if doing so would adversely affect the representation of one of the organization's clients whose interests are adverse to those of the client of the lawyer. E, law firm activities affecting client interests. 1, activities that may harm the client and activities that may benefit the client. So for those causing harm, the lawyer may serve as a director, officer, or member of a law reform group, even though a reform advocated by a group may harm one of the lawyer's clients. 2, activities that may benefit the client when a lawyer is working on a law reform project and is asked to participate in a decision that would materially benefit one of the lawyer's clients. The lawyer must disclose that fact, but the lawyer need not identify the client. Assisting in judicial misconduct. A lawyer is subject to discipline for knowingly assisting a judge or judicial officer in conduct that violates the Code of Judicial Conduct or other law. Model Rule 8.4F. All right, and I read the remaining sections on all of the political appointments of legal officials, judicial office officials. Judicial ethics, part 12. I am going to use this time to go over this section just because there will be a couple of questions, maybe 3 in the exam. So it's worthwhile to read 20 pages of this outline right now. Especially considering I've been tested on this and I don't have an idea what's going on. So in judicial ethics, A, selection, tenure, and discipline of the judges. 1 is federal, 2 is state, 3 is the Code of Judicial Conduct. and explains further the adoption of the Judicial Conduct Code, who is subject to the Judicial Conduct Code, and the form of the Judicial Conduct Code. So for now, I'm going to talk about how the federal judges hold office for life during good behavior. That's all part of the Constitution, can be removed by impeachment, or can be disciplined in less drastic ways by a committee of federal judges, and generally governed by the Code of Conduct for U.S. judges, which is based largely on the ABA Model Code of Judicial Conduct. Justices of the SCOTUS, however, have assured that they are not bound by the Code of Conduct for U.S. judges or the ABA Model Code of Conduct, and that comes from Cheney versus United States District Court, Scalia's opinion in 2004. State judges, however, the Constitution in most states specify how judges are to be selected. In some states, judges are appointed by the governor, while in others they are elected by the voters, and still other judges are initially appointed and later retained or rejected by voters. State judges can be removed from office or otherwise disciplined in accordance with the state constitutional and statutory provisions. So then there's the ABA's code from established 1924, which I may save myself time reading it rather than this outline. Nonetheless, Part B in this section is the promotion of judicial integrity and avoidance of appearance of impropriety. 1, compliance with law. Okay, so you want to uphold and promote the independence, integrity, and impartiality of the judiciary and avoid both actual impropriety and the appearance of impropriety. And so 1, compliance with law and promotion of public confidence in the judiciary. A judge must comply with the law and the code. A judge must avoid even the appearance of impropriety at all times. The judge must act so as to promote public confidence in independence, integrity, and impartiality. Test for appearance of impropriety. An appearance of impropriety arises when a judge's conduct would create a reasonable perception that she has violated the CJC or acted in some other manner that reflects adversely on her honesty, impartiality, temperament, or fitness as a judge. Community outreach. To promote public understanding of and confidence in the administration of justice, a judge should initiate and participate in community outreach activities. For abuse of judicial prestige, a judge must not abuse or permit others to abuse the prestige of her office to advance her personal or economic interests or those of others. Which starts that section, actually the only part in that section is references and recommendations. Based on personal knowledge, a judge may not act as a personal reference or provide a recommendation for someone. Such a communication may be on official letterhead if 1, the judge indicates that the reference is personal, and 2, there is no likelihood that the use of the letterhead would reasonably be perceived as an attempt to use the judicial office to exert pressure. So Part C under this judicial model code or judicial ethics is impartial, competent, and diligent performance of judicial duties. The CJC requires a judge to perform the duties of the judicial office impartially, competently, and diligently. Judicial duties in general is Part 1. Judicial duties include the duties of the judge is office that are prescribed by law. Judicial duties take precedence over all the judge's other activities, including personal and non-judicial activities. Hearing and deciding matters assigned. A judge must hear and decide all matters assigned to her except those in which disqualification is required. Disqualification should not be used as a tool to avoid cases that present difficult, controversial, or unpopular issues. There's impropriety and unfairness, or fairness, I should say. A judge must uphold and apply the law and must perform her duties fairly and impartially. 4th, external influences on judicial conduct. Public clamor or fear of criticism must not sway a judge. Family, social, and political or financial interests must not influence a judge's conduct or judgment. A judge may not convey or allow others to convey the impression that anyone is in a position to influence a judge. 5, competence, diligence, cooperation. A judge must perform her judicial and administrative duties competently and diligently. Competence requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary to perform the judge's responsibilities. To accomplish prompt disposition of the court's business, a judge must 1, devote adequate time to her duties, 2, be punctual in attending court and expeditious determining matters submitted to her, and 3, take reasonable measures to ensure that court officials, litigants, and attorneys cooperate in this regard. In this regard. Also, a judge must cooperate with other judges and court officials in the administration of court justice. Ensuring right to be heard. A judge must allow every person with a legal interest in a proceeding the right to be heard according to law. Although a judge may encourage settlements, he must not act so as to coerce a party into settlement. It is important to keep in mind the possible effects of a judge's participation in settlement talks, the effects of the judge's views on the case, as well as on the parties' perceptions if the judge retains the case following unsuccessful negotiations. And factors for determining appropriate settlement practice. When deciding on an appropriate settlement practice, the judge must consider the following factors. 1, whether the parties have requested or consented to a certain level of participation by the judge in settlement decisions, whether the parties and their attorneys are relatively sophisticated in legal matters, whether the case will be tried by judge or jury, whether the parties participate with their lawyers in the discussions, whether the parties are not represented by counsel, and whether the case is civil or criminal. Avoidance of bias, prejudice, and harassment. A judge must avoid bias, prejudice, and harassment, and must require others, including lawyers, who are under the judge's discretion or direction and control, to do likewise. This includes race, gender, bias, religion, disability, political affiliation, economic status, marital status, social, economic. Harassment consists of verbal or physical conduct that denigrates or shows hostility or aversion towards a person on any of the above. A judge's duty to control lawyers does not preclude legitimate advocacy by lawyers when issues of prejudice arise in a case. A judge should be aware that facial expression and body language can convey prejudice as easily as words. Ex parte communications. Ex parte means one side only. Communicating between a judge and a representative on one side of the matter when no representative from the other side is present. A judge must not initiate, permit, or consider ex parte communications except in the following 3 situations. 1, expressly authorized by law, court rules, or decisional law, as well as constitutional or statutory law. Some communications authorized by the law occur in conjunction with the judge's service on certain specialized courts, such as drug courts or mental health courts. Judges serving on such courts may have to assume more interactive role with parties, treatment providers, probation officers, and social workers. Mediation or settlement so this is the second exception. With the consent of the parties, the judge may confer separately with the parties and their lawyers in an effort to settle or mediate a pending matter. Emergencies and administrative matters. There are 4 parts here. The circumstances, all 4 have to be met. The circumstances require the judge to communicate with one side only if the other side cannot be reached. 2, the communication concerns an emergency or a scheduling or administrative matter as distinct from a substantive matter or matter reflecting merits. 3rd, the judge believes that no party will gain procedural, substantive, or tactical advantage from the communication. And 4, the judge notifies the lawyer of the other party of the absence of the communication and gives the opportunity to respond. D, inadvertent receipt of unauthorized ex parte communication. If a judge inadvertently receives an unauthorized ex parte communication that relates to substantive matters, she must make provision promptly to notify the parties of the substance of the communication and give them the opportunity to respond. And that's the last part of the ex parte communications. Communications from others is part 9, and you have court personnel and disinterested legal experts. So, however, the judge, may consult about a matter with judges and with other court personnel whose function it is to aid the judge in carrying out adjudicated responsibilities. For example, the judge's law clerk. However, 1, the judge must make reasonable efforts to avoid receiving actual information that's not part of the record, and 2, must not abrogate his responsibility to decide the matter. So he, if it's a bench, must decide the matter. Disinterested legal experts. You've got the judge may obtain the written advice of a disinterested expert on the applicable law, provided that the judge gives advance notice to the parties of the expert's identity and the subject matter of the advice to be solicited, and gives the parties a reasonable opportunity to object and respond to the notice or the advice. Independent investigation of facts. A judge must not independently investigate the facts in a case and must consider only the evidence presented. This prohibition extends to information available in all mediums, including electronic research, like on the internet. And public comments on cases, this is 11. That was 10. Coming after 9, which is communications with other parties. So 11 is public comments on cases. When a case is pending or impending in any court, a judge must not make any public comment that might reasonably be expected to affect its outcome or impair its fairness, or make a non-public comment that might substantially interfere with a fair trial. The judge must require like abstention from court personnel under her control. Official duties accepted, A, and B, judge as a party, are subparts in this public comments on the case. So the duty to abstain from comment does not prohibit judges from making the public statement in the course of their official duties or from publicly explaining court procedures. What's the course of their official duties when is that gonna require a public statement? And when the judge is a party, the duty to abstain from comment does not apply if the judge is a litigant in a personal capacity. The duty does not, however, if the judge is a litigant in an official capacity as a writ of mandamus proceedings. That sounds cool. 12, promises with respect to cases likely to come before the court, and decorum, demeanor, and communication with jurors, administrative appointments. And the subpart within administrative appointments is appointments of lawyers contributing to the judge's election campaign. 15, responding to judicial and lawyer misconduct. If a judge has knowledge that another judge has violated CJC in a manner that raises a substantial question as to the other judge's honesty, trustworthiness, or fitness as a judge, the judge must inform the appropriate authority. The same duty applies if the judge has knowledge that a lawyer has committed a similar violation of the professional conduct. A judge who receives information indicating a substantial likelihood that another judge is violated must take appropriate action. What appropriate may range from direct communication with the alleged violator to reporting the suspected violation of the appropriate authority. So that was one of the questions I was asked in a practice test. 16, disability and impairment of other judges or lawyers. A judge having a reasonable belief that the performance of a lawyer or another judge is impaired by drugs or alcohol or mental, physical, or emotional condition. Must take appropriate action, which may include confidential referral of a lawyer or official justice to a lawyer or judicial assistance program. If the conduct of the impaired person is sufficiently serious, the judge may be required to report the person to the appropriate disciplinary authority. 17, cooperation with disciplinary authorities. A judge must cooperate and be honest with judicial and lawyer disciplinary agencies. Retaliation against a person known to or suspected to have cooperated with an investigation of a judge or lawyer is not permitted. Disqualification. General rule, whenever impartiality might reasonably be questioned. A states a broad general rule or disqualification of a judge must disqualify himself in a proceeding in which a judge's impartiality might reasonably be questioned. Disqualification of federal judges is governed by Title 28 of the United States Code, Section 455. Note that the rule employs a reasonableness standard. A far-fetched argument or litigant's whim is not sufficient to disqualify a judge. Citing some cases, due process is required. Recusal when state Supreme Court justice received campaign contributions in an extraordinary amount from and through the efforts of a board chairman or principal officer of the corporate party. Other parts of the general rule is the disclosure by the judge, the rule of necessity, bias or personal knowledge and prior involvement, economic interest come under disqualification of their own kind. And within economic interest, there is 1, the definition of economic interest, 2, exceptions, which is mutual funds and securities held by an organization, as well as bank deposits, mutual insurance policies, and the like, and government securities. Involvement in the proceeding also comes under disqualification, as well as persons making contributions to the judge's election campaign, public statements of judicial commitment, and remittal of disqualification. This all comes before the extrajudicial activities section. So in this disqualification, this is kind of important. Just read the reasonableness rule, which is a broad general rule on disqualification of a judge to recuse when a judge's impartiality might reasonably be questioned. Reasonableness standard can't be like attenuated or unreasonably attenuated. So examples, disclosure by judge. A judge should disclose on the record any information the judge believes on that the parties or their lawyers might consider relevant to the question of disqualification, even if the judge believes there is no reasonable basis for it. Rule of necessity. Case law has created a rule of necessity that overrides the rules of disqualification. For example, suppose that Judge Z is the only judge available to rule on an emergency motion for a temporary restraining order. Judge Z may rule on a motion even though he might be disqualified were it not for an emergency. Even in such a situation, Judge Z should disclose the grounds for disqualification on the record and should use reasonable efforts to transfer the matter to a different judge as soon as possible. Bias or personal knowledge. A judge must disqualify himself if there's reasonable ground to believe that the judge has a personal bias concerning parties or a party's lawyer to the personal knowledge of relevant evidentiary facts. Disqualifying the bias must be personal and stem from an extrajudicial source. Adverse attitudes toward a party formed on the basis of evidence presented in a case are not disqualifying, which I find surprising. C, prior involvement. A judge must disqualify himself if the judge previously, 1 through 5, 1, served as a material witness, served as a lawyer, was associated in the law practice with the person who participates financially as a lawyer in the matter, presided as a judge of the matter in another court, or served in governmental employment and in such a capacity participated personally and substantially as a lawyer or public official concerning the proceeding, or publicly expressed in such a capacity an opinion concerning the merits of the particular matter in controversy. D, economic interest. A judge is disqualifying himself if he knows that he, either as an individual or as a fiduciary, has an economic interest in the matter or in one of the parties. So economic interest means that the person, okay, so some interesting shit here is about the spouse of the judge, just like missed that, domestic partner, parent, or child, or by other member of the judge's family who resides in the judge's household, the judge must keep informed about his economic interests and must make a reasonable effort to keep informed about the economic interests of the judge's spouse or domestic partner and minor children residing in the judge's household. Okay, so that would be an interest in the outcome if it's held by someone in the judge's household. Definition of economic interest for this section is a person owns more than one de minimis legal or equitable interest. A de minimis interest is an insignificant interest that raises no reasonable question regarding the judge's impartiality. Okay, so owns more than a de minimis legal or equitable interest. And exceptions to the definition, like I just said, was mutual funds, securities held by organization, bank deposits, government securities. I'm not going to go into anything because nothing's highlighted, underlined, except for 1 and 2 in mutual funds. The judge participates in the management of the fund or the proceeding could substantially affect the value of the interest. Those are the only times that mutual funds matter in the question of economic interest. So those are exceptions to the exception. E, involvement in the proceeding. A judge must disqualify himself if the judge knows that she, her spouse, or domestic partner, or a person within the third degree of relationship to either of them, or spouse or partner of such person is a party, or an officer, director, general partner, managing partner, trustee of a party. A lawyer in the proceeding, a person with more than a de minimis interest that could be substantially affected by the proceeding and likely to be a material witness in the proceeding. And 1, meaning of third degree relationship. Persons within the third degree of relationship are great-grandparents, grandparents, parents, uncles, aunts, brothers, sisters, children, great-grandchildren, grandchildren, cousins, nieces, nephews, in short, anyone more closely than a cousin. Persons making contributions to judges' election campaign. A judge who is subject to public election must disqualify himself if he knows or learns through a timely motion that a party's lawyer, a law firm of a party's lawyer has, within a designated number or prior years, make contribution to the judge's election campaign that exceed the jurisdiction specified amount. Public statements of judicial commitment. A judge must disqualify himself if he, while a judge or candidate for judicial office, has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit the judge to reach a particular result or to rule in a particular way in the proceeding or controversy. Remittal of disqualification. The parties and their lawyers can waive all of the foregoing grounds of disqualification except personal bias concerning a party or a party's lawyer. The procedure for remittal is as follows. 4 steps. 1, the judge discloses on the record and gives the ground for disqualification. The judge may then ask whether the parties and their lawyers wish to discuss a waiver. The lawyers consult privately with their respective clients. All of the parties and the lawyers meet outside the presence of the judge and agree that the judge should not be disqualified. The agreement must be incorporated into the record. If a judge is willing to do so, she may proceed with the case. Extrajudicial activities. A judge must conduct his personal and extrajudicial activities to minimize the risk of conflict with the obligations of the judicial office. In general, 1, 2, and 3, participate in activities that will interfere with must not participate in activities that will interfere with the proper performance of the judge's duties, lead to frequent disqualification, or reasonably appear to undermine the judge's independence, integrity, and impartiality. 2, engage in conduct that would reasonably appear to be coercive. Or 3, use court premises, staff, stationary equipment, or other resources except incidentally for activities that concern the law, legal system, or administration of justice unless such additional use is legally permitted. So 2 is governmental hearings and consultations. We had a question on this. A judge must not appear voluntarily at a public hearing before or otherwise consult with an executive or legislative body or official except on matters concerning the law, legal system, or administration of justice. However, this duty does not apply when a judge is acting pro se in a matter that involves a judge or his interests, or when the judge is acting as a fiduciary. Also, the judge does not apply in connection with matters about which the judge acquired knowledge or expertise in the course of her judicial activities. 3, testifying as a character witness. 4, governmental committees and commissions. The judge must not accept an appointment to one of those because they can be time-consuming, controversial, interfere with the independence, but can attend a ceremonial occasion. 5, participation in educational, religious, charitable, fraternal, and civic organizations and activities subject to the general restrictions on extrajudicial activities. A judge may take part in activities sponsored by organizations or governmental entities associated with the law and legal system and the administration of justice, and those sponsored by or on behalf of educational, religious, charitable, blah, 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 that I just read. Included among such permissible activities includes a long list of 6 things. So like fundraising, soliciting of contributions for the organization from members of the judge's family or from judges over whom the judge has no supervisory or appellate authority, membership solicitation, appearing or speaking, like an award event or an organizational event, making recommendations to a fund granting association in connection with its programs and activities, but only if the organization is. So recommendations. They have to be like legal participants. Service as an officer, director, trustee, or non-legal advisor unless it is likely. That the organization will be engaged in proceedings that would ordinarily come before the judge. Encouraging, what was it? Okay, that was 6. So encouraging pro bono service. The judge may encourage that. However, not use coercion or abuse, proceed to office. Affiliation with discriminatory organizations. So they cannot hold membership in a discriminatory organization, which is like your Ashmount Golf and Tennis Club for Caucasian males. Determination of discrimination. Exercise of religion does not violate the rule. Immediate resignation is required upon learning that he belongs to an organization that practices invidious discrimination. And use of non-public information. This is 7. Non-public information cannot be disclosed unrelated to judicial activities. And 8, financial, business, or remunerative activities. I always thought it was remunerative. Generally, a judge may not serve as an officer, director, manager, general partner, advisor, or employee of a business. However, a judge may hold and manage their own investments and those of their family that may manage or participate in a business closely held by the judge or family member, or in a business primarily engaged in investing financial resources, unless 1 through 4 happens, it interferes with proper performance of the judge's duties. It leads to frequent disqualification and frequent transactions and continuing business relationships with lawyers or other persons likely to come into the court on which the judge serves, or a result in a violation of other provisions. So A and B. A is divesting problematic interests as soon as practicable, and B, minimizing time spent on business activities. 9, acceptance and reporting of gifts, loans, bequests, benefits, or things of value. Gifts acceptable without reporting is those with little intrinsic value, plaques or certificates. Things of value from individuals whose appearance would require the judge's disqualification in any event, which is friends, relatives. So you'd be disqualified if friends or relatives were before you in court anyway. They give you something expensive. You don't have to report it because you're going to recuse yourself anyway, ordinary social hospitality, commercial or financial opportunities, including discounts on loans or regular course of business, provide opportunities are available at the same terms as similarly situated persons who are not judges. Rewards or prizes given to participants in drawings and contests that are open to persons who are not judges. That was asked. Scholarships or fellowships that are not, similarly available to others in similar situations. Books, magazines, journals, or other resource materials supplied by publishers on a complimentary basis for official use. Gifts, awards, or benefits associated with the business or separate activity of a spouse, domestic partner. That was asked. The judge's household. Gifts that must be reported are, according to Rule 3.15, incidents of public testimonial, invitations to the judge or spouse, domestic partner, or guest to attend without charge to an activity relating to the law, legal system, or administration of justice, or an event associated with the judge's educational, religious, or blah, 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 civic activities permitted by the CJC. If the same invitation is offered to non-judges or similar ways, engaged in similar ways in the activity, and gifts, loans, bequests, other things of value if a source is a person who has come or is likely to come before the judge and whose interests have come or are likely to come before the judge. Fiduciary activities, generally a judge must not serve as an executor, administrator, trustee, guardian, or other fiduciary. However, a judge may serve in the capacity for a member of their family. If the service does not interfere with the judge's judicial duties, involve the judge in proceedings that would ordinarily come before him, or involve the judge in adversary proceedings in the court on which the judge sits or one under its jurisdiction. Financial dealings as fiduciary, conflicting duties, and fiduciary who becomes a judge must comply with the rule. That all comes under the fiduciary activity section. So that, again, is financial dealings as a fiduciary. Those restrictions on financial dealings that apply to a judge personally also apply when a judge acts as a fiduciary. Conflicting duties, when the duties of fiduciary conflict with the judge's duties, the judge should resign as a fiduciary, and fiduciary who becomes a judge must comply with the rule. If a person serving as a fiduciary becomes a judge, she must comply with the rule as soon as reasonably practicable, but no later than 1 year. 11, service as an arbitrator or mediator. 12, practices of law. So these can't be done full-time. But does not prevent a judge from participating as part of regular judiciary activities. For the arbitrator mediator section, but practice of law may not be done full-time. However, a judge may act pro se and may, without compensation, give legal advice or draft review documents for a member of the family. Compensation for extrajudicial activities, reasonable compensation for judges' extrajudicial activities, compensation for speaking, teaching, writing, is permitted unless acceptance thereof would reasonably appear to undermine the judge's independence, integrity, or partiality. With any such compensation must be reasonable and commensurate with the task performed. Reimbursement of expenses and waiver of fees or charges unless otherwise prohibited by the CJC, a judge may accept reimbursement of necessary and reasonable expenses for food, travel, lodging, or other incidents, waiver of fees or charges for registration or tuition from sources other than the judge's employer if the expenses are associated with the judge's participation in extrajudicial activities permitted by the CJC. Reimbursement for expenses may not exceed those actual costs reasonably incurred by the judge, and where appropriate, her spouse, domestic partner, or guest, a judge who accepts reimbursement of expenses or waivers of fees must comply with the public reporting requirements of 315. A fact within that section, reimbursements of expenses and waiver of fees or charges is factors a judge should consider in determining propriety of reimbursement of fee waiver. There are obviously those that appear to undermine the independence, integrity, or partiality. And then there's Romanet 1 through 8. Whether the sponsor is an accredited educational institution or bar association, whether the funding comes largely from numerous contributors rather than from a single entity, and is earmarked for programs with specific content, whether the content is related to a subject matter of litigation pending or impending before the judge, or to matters likely to come before the judge, whether the activity is primarily educational rather than recreational, whether the costs are reasonable in comparison to costs of similar events sponsored by the judiciary or bar associations, whether information related to the activity and its funding sources is available upon request, whether the sponsor or source of funding is generally associated with parties or interests currently appearing or likely to appear in the judge's court, thus potentially requiring the judge's disqualification under Rule 211, whether differing viewpoints are presented and whether a broad range of judicial and non-judicial participants are invited, whether a large number of participants are invited, or whether the program is designated specifically for judges. 15 is the reporting requirements. A judge must publicly report the amount or value of, oh my God, there's a lot of things. There's only 3 things here. Sorry, my bad. Compensation received for extrajudicial activities permitted by 312, gifts or other things, unless the value alone in aggregation, blah, 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 in a calendar year does not exceed the dollar amount determined by state law. And 3, reimbursements, expenses, and waiver of fees we just talked about, permitted by Rule 3.14, unless the amount alone or in aggregation is below the statutory amount. A, B, or C under reporting requirements. A, contents of the public report, time for making the report, and location of the filing. Giving the source is important for the contents of the public report. Annually is the time for making the report. However, reports of reimbursement of waiver of fees or charges must be made within 30 days of the conclusion of the event of the program. Location of the filing of these public reports is the office of the clerk of the court or which the judge sits, or in some other office designated by law. If feasible, reports must be filed on the court's website. Judges' political and campaign activities is Section E, which is the second to last section, the penultimate section. The last section is application of the Code of Judicial Conduct. Penultimate. Judges' political and campaign activities. A judge or candidate for judicial office must not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. A person becomes a judicial candidate when she publicly announces her candidacy, declares or files with the election or appointment authority, authorizes or, where permitted, engages in solicitation or accepts contributions or supporters nominated for election and appointment to office. 1, political and campaign activities of judges and judicial candidates in general, except where permitted by law or by rules 4.2, 4.3, 4.4 of the CJC. A judge or judicial candidate must not. And there are 13 things I'm going to number that the judicial candidate cannot: lead or hold office in a political organization, make speeches on behalf of a political organization, publicly endorse or oppose a candidate for public office, solicit funds or pay an assessment to or contribute to a political organization or candidate for public office, attend or buy tickets for dinners or other events sponsored by political organizations or a candidate for public office, publicly identify himself as a candidate of the political organization, seek or accept or use endorsements from a political organization, personally solicit or accept campaign contributions other than through a campaign committee authorized in 4.4, use or permit the use of campaign contributions for private benefit, use court staff, facilities, or other court resources in her campaign, knowingly or with reckless disregard for the truth, make a statement that is false or misleading or that omits facts necessary to make the communication considered as a whole not materially misleading, make a statement that would reasonably be expected to affect the outcome or impair the fitness of a matter pending or impending in any court, or lastly, in connection with cases, controversies, or issues that are likely to come before the court, make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties or judicial office. Then there is A through E under this 1, political and campaign activities of judges and judicial candidates for office. A, activities of other persons, no family exception or prohibition against candidate endorsement. Participant in caucus-type elections is permitted. Responding to statements by others, pledges or promises. Within pledges or promises is some highlighted text. If a reasonable person would think that a candidate has specifically undertaken to reach a particular result, then a pledge, promise, or commitment has been made. Note, however, that the statement of personal views on legal, political, or other issues is not prohibited. SCOTUS has held that announced clauses, i.e. prohibitions on political candidates announcing their views on disputed legal or political issues, violates the First Amendment. And so you see 1 and 2 under this, which is promises related to judicial organization are permitted, and 2, responding to media questions requires caution. 2, under this section of judges' political and campaign activities is political and campaign activities of judicial candidates in public elections. They must do the following: act in a manner consistent with the independence, integrity, and impartiality of the judiciary, comply with applicable election campaign, and campaign fundraising laws and regs in the jurisdiction, review and improve the content of campaign statements and materials produced by the candidate or her campaign committee before the dissemination. And 4th, take reasonable measures to ensure that other persons do not undertake on her behalf activities that the candidate is prohibited from doing. Certain activities are permitted. This is, unless prohibited as law, the candidate for elective judicial office may no earlier than a minimum amount of time, but to be determined by other state law prior to the first applicable primary caucus or general or retention election, do the following: establish a campaign committee pursuant to 4.4. Speak on behalf of your candidacy through any medium. Publicly endorse or oppose candidates for the same judicial office for which she's running. Attend or purchase tickets for dinners or other events sponsored by a political organization or public candidate for public office. Seek, accept, or use endorsements from any person or organization other than a partisan political organization and contribute to a political organization or candidate for public office, but not more than a maximum dollar amount to be determined by each jurisdiction to any one organization or candidate. So essentially, when they're running for public office, rather than running to keep their seat or running as to be a judge, you can't do any of that. But when you're running to be a judge yourself, you can do that stuff that intersects with political organizations or official offices, agencies, whatever. Exception: candidates in partisan elections may be identified with political organizations. So, unless prohibited by law, a judicial candidate in a partisan election may not, earlier than a minimum amount of time designated by other state law prior to the first applicable primary caucus or general election, identify yourself as a candidate of a political organization and seek, accept, or use endorsements of a political organization. So that's an exception from perhaps one of the permitted certain activities that are permitted, but it might have been an exception that I see underlined here: seek, accept, or use endorsements from any person or organization other than a partisan political organization. I don't know. 3, activities of candidates for appointive judicial office. 4, campaign activities, of which you see A, B, and C. Solicitation time limits, campaign contribution limits, and disclosure requirements. And 5th, activities of judges who become candidates for non-judicial office. When a judge becomes a candidate for a non-judicial elective office, she must resign her judgeship unless applicable law permits her to retain her judicial office. If the judge becomes a candidate for a non-judicial appointive office, she need not resign her judgeship, provided that she complies with all other provisions of the CJC. And lastly was F, application of the Code of Judicial Conduct. In jurisdictions that adopt the Code of Judicial Conduct, it applies to all persons who perform judicial functions, including magistrates, court commissioners, and special masters and referees. The application section of the CJC contains a group of highly detailed exceptions that make various parts of the CJC inapplicable to several categories of retired and part-term judges. If your purpose in reading this book is to answer a specific question about the conduct of a person, you should examine the application section of the CJC with care. On the other hand, if your purpose is to prepare for the multi-state responsibility examination, we suggest that mastering the detailed exceptions is not the best use of your time, and that you should be content with the following broad generalizations. A retired judge, subject to recall, is allowed to serve as an arbitrator or mediator, except while serving as a judge, and is allowed to serve as a fiduciary. 2, continuing part-time judges, periodic part-time judges, or pro tempore part-time judges are exempt from many, but not all, of the CJC provisions that restrict outside activities and political activities. That's page 155 of this Barbary outline. Yeah, I recorded